So in this video, we're going to talk about contracts and restraint of trade. And this figures in the assignment where we have two things we need to do. Draft a restraint of trade clause for an employee in your business and explain why this restraint would be enforceable if it was taken to court. Now let's start with a recap on what we mean by contracts and restraint of trade. So the definition is simply a term of a contract preventing a person from engaging in some kind of business or occupation. So typically this stops a person from starting a business of their own, competing with the sale of business, or simply moving to another employer and doing the same job they did for you. So the three examples here: restraint in an employment contract, which is what you will draft for the assignment, and it's usually for a given period of time or geographic area, so that employees working for you don't leave and take customers with them and you lose that business. The second is when you sell a business, the purchaser wants to get the goodwill they are paying for, and goodwill is essentially the customers and to some extent suppliers for that business. And if the person who sells you the business has a good reputation and sets up in competition with you across the street, you will lose your customers. So you have a clause in the contract saying they won't do that after selling to you. The third example here are to do with the supply of products in a market. An example, Fisher & Paykel. If a retailer sells some Fisher & Paykel products, they cannot sell a competing product of another supplier. These are called tied house arrangements or exclusive dealing arrangements, and some of them may breach the Commerce Act. The Fisher & Paykel one does not. This has actually been tested in court. Now, we are going to focus on this one for the purposes of the assignment. So let's go through the law that applies to this. So now we know what they are, what happens to them. Now the first point is where we start, and that is to say that they are in fact prima facie void, which means the courts don't like them, and their starting position is you cannot enforce them against anybody. However, they will allow them if they are found to be reasonable and there's no public interest reason not to have one. Now, in your businesses, you really won't have too many public interest arguments to bring up. So your focus should be on the issues of deciding if your restraint of trade is a reasonable restraint. So we've got some steps we can work through with the restraint of trade clauses or questions. Is it a restraint of trade? Well, yours will be because you're drafting it. And it won't be enforceable unless you can prove it's in the public interest, which means it doesn't affect competition, effect on commerce, or stop people providing services to the public they need. Now, on the face of it, it does all of these things, but not to the extent where there's a public interest reason not to allow you to have it. Now, for example, if you were a medical centre in a small town in rural New Zealand and a doctor had a restraint of trade with you and moved to the next town where there was no doctor and set up in breach of that restraint of trade clause, it is unlikely you could enforce it because the court will simply say the needs of the wider public in the next town to have a doctor are more important than your need to restrain that doctor from doing the work. Now, those arguments seldom exist in most commercial businesses. The real focus here is whether it's reasonable. And all of these factors we look at come down to one question: will the employee who leaves your employment take your customers and potentially your suppliers with them? And so we need to stop them competing with us or working for other people in an area for a time that's sufficient for the customers to forget that person, and only in the areas where they worked for us. So we have these factors. It has to protect the goodwill which is being sold in the case of a sale of a business. Secondly, it should be only long enough as necessary to protect your goodwill. The third one here, geographic area and demographic, which means population, should be considered. So what is reasonable in a rural area of New Zealand of 50 miles would not be acceptable in Auckland, because 50 miles, which is 80 kilometres, would cover most of Auckland, and that's a significant part of the New Zealand population, something over a quarter of it. However, in 50 miles of a rural area in Taihape might be 10,000 people. The next point here is activities covered. If I employ a person as a builder, I can't restrain them from moving to another business as a plumber. I can only restrain them within the activities covered because that's the goodwill that they will have built up for me within the business. Now, when we finish this, we're going to come to a conclusion of saying, is it reasonable or not? If the answer is yes, we simply enforce it in court. If it's not, the court can modify these contracts to make them reasonable under the Illegal Contracts Act. So let's turn to that. So we have the Illegal Contracts Act, and if we go into Section 8, Contracts and Restraint of Trade, we can see that if any contract constitutes an unreasonable restraint of trade, so it's the focus here on it's being unreasonable, the court may, so it's a discretion, delete it or modify it. So they'll simply change it and make it reasonable. So let's now turn back to the assignment and just go through an example using the business that I have. And that business, if you recall, was to manufacture sleep outs, which I put on a truck and deliver to my clients at their houses. So to carry out this, I've got a number of employees, my apprentice, some experienced builders, an engineer who designs the actual sleep outs, an architect who's making them very pretty, works with the customers, and a project manager to carry out all the arrangements to do with installing services and connections. Now clearly this is excessive for my sleep out, but you certainly would have this in a construction and building company, and of course somebody owns the business. So in my example, we can break this up in several ways just to consider the issues here. These people are all employed. So this will be an employment contract issue here for all those people. So that would be in the employment contracts. Whereas in terms of the owner, that's going to be a sale of the business to a purchaser. Now also in terms of the employees, we can clearly say that these are the people here who do the work in the back office, and although they'll have something to do with the clients, it's not going to be a lot of time or a big part of the job. Whereas the architect is a person who often deals with clients and designs houses and these sleep outs to meet their particular needs, and people are very much influenced by a good architect in their choice of a building company. So that person is going to develop a lot of goodwill for us in our business. Similarly, a project manager whose job is to make sure the project's on time according to budget and meets all the requirements will also deal with clients and suppliers in particular a lot, and that person also will build up a lot of goodwill in our business. So these people are very important to the goodwill in our business. So we're going to draft a restraint of trade clause for one of these people. Now I'll consider all of these, but you only need to consider one. Draft a restraint of trade clause you think is acceptable. That clause is simply going to say, as when this person leaves my employment, they will not work in competition with me in the following services in an area for a certain amount of time. So if we look through these people here, our question is, will they take customers from the business, our goodwill? So we need to know how long the restraint should be, what area it should cover, and think what did they do for the business. So if we start with the time issue and think about our apprentice, how much time is reasonable to consider whether an apprentice will in fact affect our goodwill? Now the apprentice, while an apprentice, very, very little. When they're a finished builder, then they could. So maybe we could go a year. An experienced builder, that might be a couple of years. An engineer, maybe a year or two. These are the typical times. It's very seldom you exceed more than 2 or 3 years. However, an architect having such a significant effect, we might try to restrain for 3 to 5 years, although that's starting to get quite excessive at 5 years. The project manager, similarly. There's no test to this. You've simply got to say what's reasonable and what's the amount of time it would take the customers not to follow this person to a new business. The same issue arises if we were actually considering the owner. Another issue that's quite an important one here is what area and what they did for the business. So again, we'd restrain them within the types of contracts are involved in. The architect, though, we could go a little bit wider in the construction industry. So let's consider the issue of area. So I've got a map here of the Auckland, South Auckland area, and in the center I've got my factory. So I've put it in Takanini. There's a lot of industrial work around Takanini done. So I've put the factory there, and where am I going to restrain these people from acting in competition with me? So if I take the builder, for example, not very far, if I take the architect who's dealing with my clients, and let's say my clients, I'd been in Mount Wellington, I'd had people around the Manukau area, down as far as Karaka, just off from Papakura, out on the eastern side up to Maraitai, and perhaps a few people down in the country there. Now that's creating us quite a large geographic area, but for an architect that might be quite a reasonable definition. And we may go a little bit wider than that. But because our center of operation is around this area, we're not really going to go much wider than that. Of course, some of the people who bought from us when they were in Karaka might in fact move down here and ring us up and get our work. But we just have to accept that. We can't simply extend indefinitely around the country. Now, of course, this situation would change if we had our business in Auckland, and in fact we supplied in Auckland as discussed, but we're also in Hamilton, Taupo, in the Eastern Bay of Plenty around Wakatani, down to that looks like Opotiki. So in that case we could start to widen the restraint of trade, potentially like this, but that is starting to get a very big area and a very large percentage of New Zealand's population. If it's a prominent construction company, say GJ Gardner or somebody that's nationally known, then they would be able to restrain their principal architect in a very, very wide area. So in terms of answering this, you need to pick your employee. So I have got my architect, and I'm going to say cannot enter any similar employment. So it goes my activities for a period of 3 years within an area of, let's say, 25 kilometers of Takanini. And so what am I doing here? I'm going through the factors and I'm saying public interest. And really there are no public interest areas to cover here, because architects are widely available, so it doesn't affect competition, and do not provide a service of significant public need which cannot be met. Then I'm going to go through time, and what you're saying is why is 3 years okay, and that's coming down to the fact of the position, the client contact. Now clearly you're not going to write exactly what I'm writing. You're going to talk about what their position is, how many clients they were in contact with, and why you think 3 years is okay. Now you just need to give reasons for this. We can't argue with your reasons. It's very much a discussion. So what's the geographic area? And this should relate to where the business operates and has clients. The demographic is population. If you're just acting within a large population area. And activities, it only covers activities where they created goodwill in my business, which is normally whatever they actually did for us in the business. So it's a straightforward process here, and you're simply considering who am I going to restrain for how long, what area, and what activities, and you're explaining which of those, for each of those factors. Okay, and to finish off today, here's an elephant who is just beautifully constrained by a very secure security fence, keeping us very safe.